lot of misinformation, unfortunately, floating around, especially since a recent YouTube video was posted by a gentleman that was 99% incorrect and put a lot of fear into people that this is just a precursor for a land grab or the state's trying to take water rights away from people.
Luckily, that guy's video has informed a lot of people, so good thing they're calling and figuring this out. We don't want it to cost people 3 times as much, so letting our neighbors know is an important idea.
The blessing and the curse of that video is that we've been absolutely inundated with people calling and
Good afternoon, Idaho Department of Water Resources. This is Tammy.
Hi, Tammy. I had some questions about the water adjudication process.
Okay, let me get an agent for you. Hold on.
Okay, thank you.
Idaho Department of Water Resources, how can I help you?
Yeah, hi. I had a couple questions about the process, the water adjudication process that's going on.
Okay.
What do we need to do as landowners?
Well, it depends on what exactly you have as far as water use on your property and where your property is located.
If someone's drilled a well, are we not entitled to use that water?
Well, it depends. And see, per Constitution of Idaho, the water belongs to the state and the citizens of Idaho. So you are entitled to use that water, but there is water laws that affect that usage and really ensure the longevity of the resource and ensure that you don't impact other water users. So simply by drilling the well and putting the hole in the ground, the well drillers and stuff, they have permits and construction standards and registration that they have to go through to put that hole in the ground, because if it's done improperly, it could negatively affect other water users. So that's the first step in that process. And then once you start diverting and putting that water to beneficial use, per Idaho water law, if you divert from a well source for domestic or stock water purposes, not exceeding 13,000 gallons per day or a half an acre of irrigation around the home, you're exempt from the permit requirement, and it's also a deferrable use in the adjudication, which is why I asked you about your water use. If you're just small domestic or stock water, you're not required to file an adjudication claim. It's highly recommended that you do, but you wouldn't be required to. Now, if you wanted to divert more water than 13,000 gallons per day, or if you wanted to irrigate more than a half an acre around your home, then you would have to apply for a permit for that kind of usage, and that would go through the permitting to licensing structure.
So this process is kind of more designed towards much larger or very large landowners. Is that?
No, it's really for everybody. Okay, so Idaho manages our water through the doctrine called prior appropriation, which means first in time, first in right. So when you first put a water source to use, you have first right to use that if there's ever not enough water to go around. Now the problem there is if you have water rights that aren't recorded and we don't know what your priority date is or how much water you're using, if there's ever an impact to that water supply, it's essentially impossible to dictate who has the right to that water. So before that could occur, you would either have to go through a private litigation of your own and have those water rights adjudicated to find out who has a right to what, or a process such as this, which is a general adjudication that's rolling through. We started adjudicating the state in the late 80s with the southern part of the state. We've been working our way through the whole state ever since. Through a general adjudication, it pulls in everybody and allows you to get your water right recorded through an adjudication process that essentially you're not paying for. Your claim fee for a small domestic, for instance, is only $25, and for that $25, you get a decreed water right that gets litigated through the courts and decreed by a judge. So it's a small price to pay for what you get out of the deal, but that's kind of your only opportunity to get a backdated water right to when the water use first began. If you go through the application to permit process, the application date would be the date of priority moving forward. So that's what dictates your hierarchy in that short, in the event of a shortage, would be that priority date again, which is the big kicker for a water right, is what your priority date is what determines how senior your water right is. But if it's not recorded, then you really don't have any legal meat on the bone, so to speak, if there is an impact to your water supply.
Other than the fact that it's that I still have a constitutional right per the state of Idaho to actually use the water. That would be my only recourse.
Well, yeah, you can use the water, like I said, as long as you're not exceeding a half an acre and you fall within the parameters of that law. But as far as, like I said, if there was an impact, say if you're using water from a well for a home, and then a new condominium goes in 5 to 10 years down the road and sinks a new well that should draw your well down, you would call the department and say, hey, all my water's been drawn down. It's this new well across the street. First question they're going to ask is, what's your water right number? What's your priority date? So if you don't have one recorded, you would actually have to get that figured out before we could actually act on your behalf, and to figure that out, that would actually have to go through an adjudication process such as this one, or a private one that is paid for and operated by yourself. Adjudication is just an inventory of existing water uses. It's just a one-time deal that rolls through and allows you to get your water right recorded and bound to your property, and once it's done, and then it would just transfer and follow the ownership of the property from that point, unless you were to move it off the property.
So this process will never take place again in Idaho?
No, this is a one-time deal.
I mean, not even 100 years from now?
Well, there really shouldn't be. No, once it's been done, once the decree's been done, this particular adjudication, being a general adjudication, supersedes all other little ones. So like I said, as far as the smaller adjudications, when there's a dispute over not enough water in a stream and they had to go through a small litigation process and a small adjudication of the water rights involved with that stream, this big adjudication supersedes all those and essentially swallows them all up. And this is the only one that's going to come through. Mind you, as far as the deferrable water rights that we have out there, like I said, having not to claim those small domestic and stock waters, those are deferrable. But the feds, the U.S. has currently filed some motions to try and push for some sunset dates on how long those can be deferrable. So it's still a one-time adjudication that rolls through, but there's a chance that somewhere down the line we're forced through legal action that we have to adjudicate the remaining portion of all the smaller ones. So they're deferrable, which means they can be claimed at a later date, but I couldn't tell you how long they could be deferred for. And when they did have to get claimed, it would essentially be through this same adjudication. It would just be at a later time.
Okay, so if I have a small property, I don't have to claim it because of the size or the amount of water I'm using now, but I could potentially have to come back and claim it again if the federal government forces us to claim them.
Yeah, if they're able to get that motion through the court to essentially, if they put a sunset, which could come down the line, it might be 5, 10, 20 years down the road, but if they do put an end date as far as how long we can defer those, it's possible that we get forced into adjudicating everything again. However, just to give you an idea of the magnitude of what that would entail, we'd essentially have to roll through the whole state again and almost adjudicate everything all over again and require all those small domestics and stock waters to be accounted for. There's a slim chance of that happening anytime soon or even getting through, but it's possible. That's why I don't want to say never. But if that did happen, it would be a very, very long, lengthy process that goes through again. So currently, just to put it into perspective, the area that you're within right now, the Clark Fork Ponderay River Basin adjudication that we just commenced, we expect anywhere from 25 to 30,000 notices to be sent out to property owners there, and then we're expecting anywhere from 8 to 10,000 adjudication claims to be filed. There's about 5 people on staff with the state that review those claims. So if you're talking about having to go through everything again, we're going to have to get litigation or legislation passed to not only rewrite the Idaho Water law to get rid of the exemptions, but also we have to fund the offices and staff the offices to go through and get everything done again. So it's a massive undertaking if we do get forced into that corner, but I'm not too sure which direction it's going to go at this point or how soon. We just have to say that we can't say never. It's just one of those things. And as far as even if you going beyond even the requirement, if you just chose to defer to a later date, like I said, right now it's $25, but once the basin's been closed by the court, even beyond the deferrable of anything, it's eventually, once everything's been adjudicated in the area, the judge will close the basin, and at that point you can still file a late claim for that deferrable use, but you'll have to pay for the advertising costs as well as the litigation costs there and the investigation costs. So you might be looking at about $350 for that same water right claim that could cost you $25 now. So it might cost you a little bit more down the road too.
And is that per property then?
Oh, that'd just be per water right.
So is the water right your property and the water that you use, or is that like I have one well, I have a pond, is that 2 different water rights?
Well, a couple of different factors. If you have one well that's filling the pond, that's a use of groundwater, and depending on what you're using for it, that might be one water right. If you're diverting out of the pond, that could be diverting from a surface water source. That particular use, if you've either made the pond or if you're diverting from it, any diversion of surface water that starts after May 20th, 1971 has to go through the permitting process. So it'd be a different path to a water right there, but that would be one water right. Your domestic and stock water use of your well would be another water right. So it really depends on what the source is. Typically, different sources will dictate that you have to have a different water right, and then if you have one water right in place for your domestic and stock water purposes of the well, should you want to add irrigation beyond that half an acre, you'd have to apply for a permit for that, and that might be an additional water right. So it kind of depends on what the nature of the water use is, but the water right is really determined by the use, not the property.
Okay, so if I have 4 different water sources that my animals are drinking from, am I still having to get permits for those 4 water sources for them to drink out of, or am I exempt?
Okay, so that's where I touched on stock water and being included in the deferrable and exempt stock water from a groundwater source, meaning that if you're diverting out of your well to fill stock tanks, that's an exemption there. So that falls in there with the domestic. De minimis is really the legal term for it, de minimis domestic and stocks. If your stock are drinking out of existing water that's just on your property, such as a stream, pond, spring, anything like that, as long as you haven't taken control of that in any way and diverted or developed it in any way, and there's just water there that they drink out of, that's also an exemption. You don't have to have a water right in place for that. That's known as in-stream stock water. We don't chase cows out of streams or anything like that. If there's water there, they can drink out of it. However, if you put a pump into any of those and you divert that water out, that would require a water right.
Okay. So what's the downside then? What's the downside if someone just does not go along with this at all?
Well, the downside is number one, like I said, you wouldn't have a recorded water right. So if your water supplies were ever impacted by a neighboring water user, you don't have that legal meat on the bone, so to speak, to go after that and get that injury resolved or to get that water resumed to you. The other side of that is if you happen to be diverting water or using water in an unlawful way, and there's ever a complaint filed or a water master should discover that in the future, there might be a notice of violation written to you, and, any kind of violation notices or penalties that might incur with that down the road.
So you potentially will just get fines and go through that process of being fined and more fines.
If it's an unlawful use, then you'd get a cease and desist, and really we have, depending on the nature of the use, and if there's no compliance there, we have authority through state law to put a padlock on the diversion works too. We can lock everything down if we absolutely had to. More than likely, though, typically in that kind of a situation, you get a notice to either apply for the water right, get everything into compliance, or cease and desist as far as the usage go. It's generally, handled. You don't have a hammer that drops on you immediately. We usually give you a little bit of leniency and try and handle it tactfully and work with you as best we can on that. But it will kind of depend on the nature of the use and what's occurring and to what extent. And if there was injury to other water users too, if you're using water unlawfully and that should negatively affect somebody that has a lawful water right downstream of you, then you might have some instances that come up with that too.
So yeah, this is the part that I'm always interested in, right? Is what is the where do the teeth come in on the enforcement? So you guys can come out and put essentially a lock on someone's wellhead. Is that what you're saying? And I understand this is past the fining parts.
Well, yeah, this is past getting a notice of violation and everything. But yes, we have legal authority through Idaho Water law to lock down your diversion works if you're using water unlawfully.
Okay, so this whole process, do I have to allow someone to come onto my property to inspect all of the water sources?
It depends on what you're filing a claim on. Technically, like I said, we do have legal authority to investigate that and to come on your property to look at things if we need to. But depending on the nature of your claim, if it's just a small domestic and stock water use of a well and we can see everything through aerial photo and we have no need to go to your property. If you have a diversion into a pond and we can't ascertain, the size and extent of the pond that you're claiming through aerial photo or through the data submitted. We might have to take measurements ourselves on site, or if you're filing an old, an irrigation water right, we need to measure how many acres are out there, things like that, and it's obstructed from tree cover, things like that. There's some instances that we might have to, or if we have to do a pump test, to see what the actual diversion capacity is, depending on what you claim. In some instances, we have to do a test to make sure that the amount of water claimed matches. Like I said, on small, de minimis, domestic, and stock water uses, those typically aren't anything that we investigate unless we have to.
So you're telling me you guys have the authority to go onto private property to inspect, like if you see like a pump in a pond, you have the authority to go onto private property and inspect that?
If you file an adjudication claim, then yes, we have an
No, I'm saying
to investigate the nature of that claim. If you're using water unlawfully, we have legal authority to approach the curtilage. So if there's a complaint filed against you, we can approach, we can go to your doorstep. We can, notify you that way. Typically, you're going to be notified. We don't just go onto private property, and especially if it's posted, we don't go onto people's private property. We would notify you of the fact before we did so.
Okay, that's the part I was wondering, because I know that with our trespassing laws, a gate and no trespassing signs pretty much keeps everybody out. So that's
we're not just going onto private property.
I didn't think so. So
no, but if there's a water use violation that we can see from the road or through aerial photo, or if there's a complaint filed against you, you're going down a lot of hypotheticals that go into a lot of different directions. So it really kind of depends on the actual situation as far as what might be done.
Yeah, and I'm not trying to take you out a bunch of hypotheticals. I'm just kind of wondering, like, when you're talking about a diversion from the water right, what it is we're talking about. But I think I got you. My biggest concern, my use, is my animals. So I'm just trying to figure out if this is going to cost me a bunch of money because my cows drink from the existing water.
No, well, and like I said, it depends on what kind of water they're drinking from. If there's just existing water through your property that they drink from, it either doesn't cost you anything, because like I said, it's not required to be documented. You don't have to have a water right for it at all. So that's a zero cost. Or if you wanted to get that cost recorded and then that use recorded so that you've got that protection to assure the water's always there for your stock, depending on the nature of that use, it could be a small $25 charge, or generally for stock, that's really it. If you're diverting into a larger storage tank, or you have a reservoir that you're diverting that exceeds that 13,000 gallons per day limit, and you're going to a larger quantity, then you might, maybe it's a $60 charge for the claim or something like that. So it really kind of depends on how much water you're using and what kind of claim you have.
Okay, and then that 13,000.
And it's just a one-time deal too. It's not anything that comes down the road again. It's just once the claim's filed, it's done.
Yeah, I'm just kind of wondering how it is, you're granted the right to use it. Now all of a sudden down the road, 200 years later, here we are talking about a new registration of the water. And then I'm trying to figure out how in the future this creates a building block to potentially do it again. Which brings me to my next question about the 13,000 gallons a day. Will that ever be diminished, or is that the bar that's set? And you'll always be able to use 13,000 gallons a day if you,
that's currently set through Idaho state legislature. That's what's been voted through. And I keep in mind 13,000 gallons per day is an obscene amount of water.
Oh, it's a ton.
Typical domestic household use. And this is, again, for just de minimis domestic and stock water uses, meaning you can't use that 13,000 gallons for anything you want. You're still limited to in-home use as well as lawn and garden, not to exceed a half an acre. But included with that, when they wrote that quantity in, was to also provide water for up to 100 head of livestock. So that's written into that quantity. So if you had your home, plus, like I said, you didn't need that permit for livestock, so that's included as long as you're not exceeding 13,000 gallons per day. For your home, a half an acre and 100 head, you could still get all of that in without having to be permitted, without even having to be recorded. Okay, so that's how Idaho set that up. Mind you, if you go to like a neighboring state just over the border in Washington, their cap is set at 5,000 gallons a day, which is significantly less, but still far greater than what the typical household use is. Typical household use might be 500 to 800 gallons a day.
Yeah.
Maybe you get up to 1,500 gallons a day for doing that irrigation around the yard. So anything beyond 1,500 gallons a day is way beyond what typical household use would be. And really, I couldn't tell you what could happen 100 years down the road if they decide we can't do 13,000 anymore. We got to go to 10 or whatever that quantity might be in the future. I really can't tell you. It would have to get voted through the legislature just like anything else, and they'd have to change that. And just like any other law that's on the books, if it gets voted through and it goes through the state legislature, then they can potentially change that. There's a lot of misinformation, unfortunately, floating around, especially since a recent YouTube video was posted by a gentleman that was 99% incorrect and put a lot of fear into people that this is just a precursor for a land grab or the state's trying to take water rights away from anybody. It's nothing of the sort. Like I said, all this is just an opportunity to get these water rights recorded so that we can manage the resource a little bit more effectively. Even if you have water on your property, yeah, you can use it, but it's well understood that water is hydraulically connected throughout an area, whether it's surface water or groundwater. You might have groundwater that flows through several different areas, several different properties. You could have a stream that flows through many different, so we really can't allow everybody to just indiscriminately use as much water as they want, because they very well could be negatively impacting other users that have first right to that water source.
Gotcha. Luckily, that guy's video has informed a lot of people, so good thing they're calling and figuring this out, because,
well, that's a good thing, yeah.
We don't want it to cost 3 times as much. What's that?
What's that now?
Oh, I was saying we don't want it to cost people 3 times as much, so letting our neighbors know is an important idea.
Well, yeah, no, and that's fine. And there's notifications being sent out for it. And like I said, the blessing and the curse of that video is that we've been absolutely inundated with people calling in a panic to figure out what's going on. So we've been able to spread that word. We did do some public outreach meetings up there a couple of years back, and we had some planned actually for this last fall and spring, but because of COVID, we've had to put those out. So unfortunately, we haven't been able to get as much of the public impact meetings out there to let you know what's going on. So anything that we can do to get the word out is help. I mean, even bad word, unfortunately, spreads faster than good word, but it's got a lot of people's attention. So if at least they, like you said, you found out what's going on because of it, then so be it. It's a benefit to you in that sense. But there will be additional public meetings. We're actually hoping to get something out there up in Sandpoint and also in Priest River here in the spring, sometime around April. We're planning on getting some more meetings out there to kind of discuss with people and let them know what's going on.
Do you guys have anything to do with the Priest Lake project that's being proposed as well?
Which Priest Lake? Well, which Priest Lake project? Just all the work they've done to the thoroughfare and the dam.
No, the pipeline that they're proposing to pump colder water into the Priest River.
Yeah,
so.
No, that's going through Fish and Game. We have nothing to do with that.
Oh, okay.
And there's a lot of pushback against that from the local community. That has nothing to do with us, unfortunately. I can tell you that. I was at one of the recent Water Resource Board meetings. I had to present to the Water Resources Board on that the same day that Fish and Wildlife had to present their idea to them. So at this point, from my understanding, that's still just in a proposal stage, and it's being met with a significant amount of resistance, so I'm not too sure how far that's going to get down the road.
Okay, perfect. Well, I appreciate it. You answered all the questions I had, so thank you for your time.
Hey, no problem at all. Any other questions come up, or if you need any assistance filing any claims or anything in the future, feel free to give us a call. We'll be happy to help you out.
Awesome. Thank you, sir. Have a good one.
Thank you. You too. Have a great evening.
All right, guys, lots of good information on that call. Man, I'm going back and forth with this thing. I don't know that I even want to enter into it. I see the good of it. I see the bad of it. But as he's talking about, Washington's bar is set at 5,000. Ours is set at 13,000. It's a bar, right? The bar has been set. It's very high in the state of Idaho. It's extremely high, right? My big worry is that it continues to get reduced over the years, over generations, right? So this is my hesitancy with this entire process, and then also just entering in to the registration process. So you enter into it and you're a part of it. I don't know what I'm gonna do. I was kind of I was on the fence with it. I don't agree with having to register stuff, right? So, but I was thinking, well, I want to protect my rights for that land in case of anything, right? Health and safety always. But then after talking to him and how I use the water on my land, I'm thinking I'm just going to go ahead and duck out of this one and stay out of it. You know, there's so many hypotheticals attached to this. You know, hypothetically, if my water is ever drained, it would allow me that recourse. Hypothetically, this could lead to them taking water and then telling you, hey, you can only use 3,000 gallons, right? So lots of hypotheticals around this. I do believe that the legislator has our rights in mind by protecting it with that 13,000 gallons. But the fact is it costs me money to enter into this process, and I really just don't feel I have to spend that money. Multiple water sources, multiple use, that's quite a bit. And if I don't enter into it now, it's going to cost me more than 3-4 times as much in the future to do it as well. So a lot to think about. Everyone's water situation is going to be completely different. Everyone's take on this is going to be different. This is either a great thing for you depending on your situation, or it's something that you don't want to enter into depending on your situation. I don't know. I'm on the fence with this. It would be a long road to travel for them to start to diminish that usage, diminish infringing on your rights. And of course it's me just, realizing that government tends to take liberties and rights, right? Just chip away at them a little bit out of a time. That's not a secret. I mean, even as a government worker, you have to realize that. That's not a secret. You've gone from using water to now someone saying, hey, you need to register your water use. In my heart, I will always believe that registration leads to confiscation, even if that's 3 generations from now. I do believe it's a foundation and a building block. The legislator is there to protect it. That's the important key to this thing, is having good legislators to make sure that they are protecting this stuff. But there's so much room for, you don't need 13,000 gallons a day. That's an excessive amount. We're going to knock that down a little bit. So it opens up that road. I don't know what I'm going to do, guys. This long video, that was a great conversation, a lot of good information. Even he saw the value in my video before, which is great to get people aware of. And it's awesome that so many people are calling to figure it out, because I know people who threw their letter away and they were like, oh, I just ignored it, man. Thank you so much. So that is good enough for me. That's all I want, is for people to make sure that they're not losing out, that the state's not causing them a hardship and more money. So I don't know. Choice is yours, guys. Thank you so much for watching, and we'll catch you on the next one.